So let's talk about a few of our highlights from tort law. Teddy's going to help me out. So this is Teddy. He's about a 1-year-old Labradoodle, and he sometimes causes harms. Let's say, especially with my 2-year-old daughter Caroline, sometimes Teddy knocks her over. So if Teddy were a person whose behavior we were trying to influence, we would say tort law is a way to create incentives for Teddy to be more careful. You hear that, Teddy? You could be more careful and not knock down Caroline. Now, we don't want Teddy to never knock down Caroline necessarily. And the reason I say that is because if Teddy were being so careful that he never knocked down Caroline, it would mean the two can't play together anymore, right? So, I mean, we're seeing that right now with coronavirus. We don't necessarily want people to take so much precaution that they bring risk levels down to zero. The reason we don't want to always do that is because it causes them to stop doing a lot of things that we want people to be able to do. We want the economy to keep running. We want people to do productive stuff. We want Teddy and Caroline to be able to play together, right? So we don't want to create such harsh incentives by giving really harsh penalties that people won't be able to do anything. We want them to take proper, efficient precaution levels. So we want them to do good stuff, we just want them to do it in a careful, reasonable way. And that's what tort liability is all about. A way to create incentives for people to take the right amount of care, the right amount of precaution. You should play with Caroline, but you should be careful with her, okay? We tell you to be gentle and be a good dog. He's a good dog, of course. Now, we talk about punitive damages as a way to ramp up incentives. And specifically, if there's a low probability someone's going to have to compensate victims, then we could use punitive damages as a way to ramp up to get them to factor in the damage that they're causing, even when they normally get away with it. We can talk about different liability regimes. If there's no liability, then people who cause harm have very weak incentives to take care. Conversely, people who are potentially injured can often help avoid injuries, and they have strong incentives to do that, right, if there's no liability. The flip side, if there's strict liability, then potential harm causers have good incentives to take care. They're going to factor in the compensation they're going to have to pay, so they take more precaution, right? Now, the problem there is that potential victims don't have a good incentive to take as much care. So the legal system has come up with these ideas of contributory or comparative negligence. So both of these are doctrines. Contributory negligence says if you, as a potential victim, were not taking the appropriate level of care, then you are not going to be able to collect from the person who injured you. That forces a potential victim to take care, and they're doing that specifically as part of a negligence regime. That means that if a potential injurer, tortfeasor, was not meeting a standard of care, we're going to hold them liable, but if they were meeting that standard of care, we won't hold them liable. And so a rational person is going to take the level of care that the law says they need to. That way they won't have to pay for injuries that they cause. Bad things happen even if we are being careful sometimes, right? So contributory negligence is a way to get both parties to take actually the efficient level of care. Another way to do it is with comparative negligence. And that says that if Teddy is 60% at fault and Caroline is 40% at fault for an injury, then Teddy is going to have to pay for 60% of the harm. 40% of the harm is going to go uncompensated because Caroline brought it on herself, which is often true, isn't it, Teddy? She's a 2-year-old, though. She doesn't really know better. Kentucky has moved to a comparative negligence standard, which is what most states, a majority of states, have done now. It's seen as more fair than a complete bar on recovery for people who had unclean hands, often called the unclean hand doctrine when we're talking about straight contributory negligence. So those are some high points of tort law to keep in mind. It's also worth thinking about some of the stuff our guest lecturer Isaac Kimes brought up about insurance companies are often representing defendants in tort cases. And so that creates some interesting situations where the tort company may have different, the insurance company, excuse me, may have different incentives than the defendant, the person who caused the injury. The insurance company is thinking about this in a different way. For individuals in court in tort cases, this is often a kind of once in a lifetime, it's a big deal, right? You're in a car accident, whether you're injured or whether you caused the injury, it's a big deal to have to go to court and fight over what happened and how bad the injuries were. For an insurance company, they're doing this all the time, and it's, to a large extent, a numbers game for them. So sometimes that means insurance companies won't be as inclined to settle as an individual might be. There could also be cases where an insurance company would want to settle, but the individual may not, depending on what they believe happened and what they think a jury will do. So the practice of tort law is quite different than the economic theory sometimes, and that's definitely worth keeping in mind. So those are a few high points of tort law. I look forward to continuing on with this. Our next topic area is going to be contract law, so that's something I look forward to.